Judge, the parties have come to an agreement, and and I was going to read into the record, but before I do that, I wanted to ask the court to take judicial notice of our modification and confirmation of arrears that was filed on or about December 23, 2024.
The court will take judicial notice of the OAG suit for modification of support order and motion to confirm support arrearage that was filed on December 23rd of 2024 for the child Angel P. Luvano.
And Judge, in particular, I want the court to take judicial notice of the final decree of divorce, which is the order that we're modifying here today, that's attached to that petition. In particular, on page number 7, it says that Angel is where it was ordered that Angel was disabled at the time, and $350 of child support was ordered in that decree, for an indefinite period, and this decree was signed June 26 of 2008.
The court will take judicial notice of the final degree of divorce signed by the court. It's dated June of 2008, but it is signed by the court on August 18th of 2008. And which page is the child support on, Mr. Darkamanjian? Do you have that?
Yes, Your Honor, page 7.
Okay. And the court will take judicial notice that on page 7 of the divorce decree, the court found that Angel Philip Luvano required substantial care and was determined to be a disabled child with a child support payment of $350 a month beginning August 1st of 2008.
And Judge, at this time, I also would offer State's Exhibit 1, which is the pay record.
You may share your screen.
Thank you, Judge.
And Mr. Luvano, do you have any objection to this pay record being admitted into evidence today?
No, ma'am.
Ms. Cooper, do you have any objection?
No, ma'am.
It'll be admitted, Mr. Darkamanjian.
Thank you, Judge. And Judge, I just wanted to make the court aware that as of yesterday, the arrears for child support is $5,372.07. And Judge, at this time, I would want to read the agreement by the parties.
Please proceed.
Judge, the parties have agreed to stop child support as of yesterday. The parties have agreed that the child support judgment as of yesterday is $5,372.07, just like the pay record says. The parties have agreed that the obligee, Ms. Cooper, will wipe out that amount of $5,372.07, where the child support judgment after release is going to be $0 as of yesterday. The parties have agreed that any monies on hold will go to Ms. Renee Cooper. And Your Honor, I would call Ms. Cooper first.
You may proceed.
Ms. Cooper, did you hear and understand what I just read into the record, ma'am?
Yes, I did.
And are you in agreement as to that?
Yes, sir.
Okay. Now you understand, ma'am, that if the court today stops that indefinite child support, that it's forever. It can never be restarted again. You understand that, right?
Correct.
Okay. How old is your child right now?
24.
Okay. And he was found disabled at what age, ma'am?
4 years old.
Okay. And why was he found disabled?
He had leukemia and a bone marrow transplant.
Okay. And after several surgeries. He's doing good now.
Yes, sir. He's
Okay.
a long-term survivor now.
Okay. And does he hold a job?
Yes.
Okay. And are you representing to the court that he's no longer disabled?
Yes.
Okay. And no one's forced you to testify here today like this. You're doing this in your own will and volition, right?
Yes.
Okay. Pass the witness, Your Honor.
Mr. Luvano, do you have any questions of Ms. Cooper based on her testimony?
Questions? No.
You may call your next witness, Mr. Darkman.
Thank you, Your Honor. State calls Mr. Felix Luvano. Mr. Luvano, can you state your name for the record?
Felix Luvano.
Mr. Luvano, did you here understand the agreement that I just read into the record?
Yes.
And are you in agreement as to that?
Yes. So right now, I just want everything to be over. So yes.
Okay. Now you understand that once we stop the child support, it can never start over again because Angel is over 18 now, right?
I'm very aware. Yes.
And you want to stop it, right?
Yes.
Okay. And do you know the jobs that Angel has held in the past?
Yes, I do.
What jobs are there? Those?
There was one recently. He was a pipe fitter helper for ICS. He was working with me. After that, he was working for the Volvo plant. There's another job for SMB in Sweeney. He was a flagger. He was working with me as well. There was another job he worked at night shift for a pipe fitter helper. There was two of them that he worked for SMB as a valve ball crew. He worked at McDonald's. He worked at a lot of jobs.
Does he drive?
Yes, he does. He drives. Yes, he does every day.
Does he have his own vehicle?
Yes, he does because of me. Yes.
Do you believe he's disabled?
Oh, no. Thank God, no.
Okay. Pass the witness, Your Honor.
Ms. Cooper, do you have any questions of Mr. Luvano based on his testimony?
No.
Okay. And Ms. Cooper, you understand you're releasing $5,372.07 today. You realize once that money is released, we can't come back at a later date and get it back.
Yes, ma'am.
And you are requesting it be released today.
Yes, ma'am.
Okay. Anything else you want to tell me, Ms. Cooper?
No, ma'am.
Anything else, Mr. Luvano, you want to tell me?
No, ma'am.
Anything else from the state, Mr. Darkman?
No, Judge.
The court will accept the agreement of the parties. The court will find that as of yesterday, Mr. Luvano, you have a child support judgment of $5,372.07. That is being released, and you have a new child support judgment of $0 as of yesterday's date. Any child support in this matter that was previously ordered, the court will find that the child is no longer disabled. So and he is over the age of 18, he's 24. So child support and any previously ordered medical support will stop as of May 12th of 2025. Any money is on hold. The parties have agreed that those will be released to Ms. Cooper. And then the court will waive any court costs in this matter so that there are no court costs for Mr. Luvano to pay.
Yeah.
So,
Judge, with due respect, isn't the family code say that it shall be assessed against the obligor?
it shall be, but the court has the right to waive them if they so choose.
Okay, Judge. Okay.
So, Mr. Luvano, your support stops as of yesterday. You no longer have any child support arrears. So your case will now be resolved after this court hearing today.
Okay.
Mr. Darkman, have they signed the order already?
No, Judge. I gotta draft it.
Okay, I'm gonna place you both back in the breakout room. Mr. Darkamangian is going to draft up the order as I've said it and as y'all have agreed. He's gonna just go over it with you, make sure you don't have any questions, and then you will both be excused. Ms. Cooper, I'm gonna send you right now to break room 29. And Mr. Luvano, I'm gonna send you to break room 30. Thank you both so much.
Thank you.
The indefinite child support was set without my knowledge or my consent. I wasn't given any information from the Attorney General or either my ex-wife as to why it was set for indefinite child support. And from my understanding, the reason why they haven't is because there is no paperwork. I'm trying to figure out, how does the Attorney General come to the determination that a child is medically unable to without a medical dossier or a medical examination, and then just determine that I'm on indefinite child support?